Hey everyone, Bruce Eckfeldt here. Thanks for checking out our YouTube channel. Make sure that you subscribe and turn on notifications so we can let you know when the next video is posted. You can also check us out at eckfeldt.com for more great content. With that, let's go check out the video.
Are you a CEO looking to scale your company faster and easier? Check out Thrive Roundtable. Thrive combines a moderated peer group mastermind, expert one-on-one coaching, access to proven growth tools, and a 24/7 support community. Created by Inc. award-winning CEO and certified scaling up business coach Bruce Eckfeldt, Thrive will help you grow your business more quickly and with less drama. For details on the program, visit eckfeldt.com/thrive. That's eckfeldt.com/thrive.
You're listening to Thinking Outside the Bud, where we speak with entrepreneurs, investors, thought leaders, researchers, advocates, and policymakers who are finding new and exciting ways for cannabis to positively impact business, society, and culture. And now, here is your host, business coach, Bruce Eckfeldt.
Welcome everyone, this is Thinking Outside the Bud. I'm Bruce Eckfeldt, I'm your host. And our guest today is John Purow, and he is a shareholder at Gottlieb Rackman Reisman. And we're going to talk a little bit about the IP, about intellectual property, about how kind of the law works when it comes to the field of cannabis. And he's with a boutique firm in New York that focuses exclusively on intellectual property. And we're going to talk about how intellectual property works in this cannabis field, particularly because of all the kind of legality, complexity, both federally and state. So I'm looking forward to this. This is going to be a good conversation. It's actually something I don't know a whole lot of. So I'm looking forward to learning and kind of expanding my knowledge on this. So John, welcome to the program.
Thank you so much for having me, and welcome to all friends of the pod, to borrow a term from another podcast that I like to listen to. I look forward to your education, Bruce. Let's try and make this as fun as possible.
I have no doubt it will be fun. On the podcast, we've talked a little bit with some folks about kind of the legality issues. We've talked about it when it comes to banking. We've talked about, kind of interstate transport and all the kind of the machinations of the state legislation versus federal legislation. So I think we have a general idea of this, but help us frame this up a little bit when it comes to the question of IP and educate us a little bit about how IP law works and then why this gets complicated from the cannabis field. And then we can talk really about how it's kind of impacting folks and what does it mean for the business people that are in the space once we kind of understand a little bit of the framework for IP law and cannabis.
Got it. So exactly like you said, you hit the nail on the head, right? In this field, just like any other, the federal illegality creates certain wrinkles that mean that we have to be a little bit more strategic. The main thing that you cannot do, right? And let's talk about, the different types of IP, right? Trademarks. Think about it as your brand. Anything that indicates source with respect to a certain type of good or service is a trademark, right? So, typically we think about a brand name, we think about a product name, but there are more unconventional types of trademarks out there. For example, I think UPS owns a federal trademark registration for the color brown in relation to, shipping and services like that, right? Their trademark only extends to that type of shipping and services. It doesn't mean that when you go number 2, you're committing infringement of their registration.
I don't have to pay a royalty to defecate.
Yes. So I told you we'd make it this interesting.
Exactly.
So the main thing that the federal illegality prevents you from doing, which everyone would love to do in the cannabis field, is to register a trademark in the name of a strain. Everyone would love to become the Marlboro of cannabis, right? And have that recognizable brand. Unfortunately, that's what you really can't do right now.
That's because trademarks are issued by the federal government.
Exactly. And what happens, to a lot of people who've tried it and tried to do it creatively is you file a trademark application for your wonderful strain name, say Purow pot, right? If I went for that, I would get a refusal from the Patent and Trademark Office on the basis that it is illegal under the Controlled Substances Act, and so you would not be permitted to proceed to registration. Now people try to start getting clever, and the basic summary is if it's a plant-touching goods or service, if it's cannabis itself or anything else that's plant-touching, you're not getting that application through to registration right now. There has been, a little bit more interesting wrinkles in relation to CBD, but plant touching, you're not going to get a registration. And so people have gotten creative and they've come up with, non-plant touching kind of ancillary goods or services like smoking products to try and get a federal trademark registration, and using this idea of kind of expanding your goods and services a bit beyond the scope of the registration, you could kind of enforce if people are trademarking, if people are infringing on the name of your strain. But right now, I mean, the main thing that you could do, and this is important because you also can't, sell cannabis across state lines, is you go for state trademark registrations in relation to if you want to trademark the name of a strain, you go for state trademark registration in any state in which you're selling. So this is, look, we have multiple clients in the space, but, and obviously besides, strong personal feelings as to why this should be legal nationwide, from a trademark perspective, there's always strategy involved in, advising clients what makes the most sense for them. But there's even more strategy in the cannabis industry because of the wrinkles specific to it.
And when do you uncross the line? Like what you talked about, people can kind of expand it, or people figure out these sort of creative or slightly expanded versions of how they do it to actually get these some level of protection. Like, where is that line? Or do you have a good example of someone who's been able to kind of make this work at some level for federally?
Here's the question, right? People have been able to get their registration for their non-plant touching products, say, smoking products and accessories, pipes or anything. Has anyone turned around and gotten to a dispute where they've used that registration on the federal level to enforce against someone infringing on the name of their strain of cannabis on a state level? I can't really think of any examples. I mean, a fascinating thing is, over on the patent side, we've finally had our first patent litigation relating to cannabis, but I think there's limited things that we're seeing in terms of conflicts like that on the trademark side. One thing that I just wrote an article about that's interesting on the trademark side is there are a number of strains out there that infringe well-known business names. So a really good example was Gorilla Glue was a very popular strain of cannabis, and that's when it was just a black market, calling it Gorilla Glue. Who's Gorilla Glue going to go after? They're going to start trying to track down and sue your dealer.
Door by door,
No, so that doesn't work. But once it became legal in certain states, they had a party to go after who was growing that, I think, in one specific state. And so we're starting to see, you're not going to see all of the enforcement related to this because a lot of it's going to happen behind closed doors with cease and desist letters. But you've seen some major brand owners start going after the strains. I mean, we saw, there's Air Jordan, but you've seen Gorilla Glue. Hershey's has been very proactive in terms of trying to tamp down on different strain names that are similar to their trademarks. And so what I would say is if you are operating dispensaries, be careful that you might get a cease and desist letter because ultimately you're going to walk away from the strain name. Right? You're not going to win that. You're going up against big brands most likely, and the cost benefit is not really going to justify fighting back.
Yeah. So talk to us a little bit about the sort of trademarks. What are the other things that come into this kind of intellectual property or protectable assets from a legal point of view?
Okay. So, I mean, the different boxes of IP are trademarks, which we already discussed briefly, copyright protection, right? So when you think of copyright protection, you're typically thinking of, a piece of music, you're thinking
some creative work,
a film, but copyright can protect a lot of, anything that has a certain amount of originality and creativity outside of say 3 words, right? You're not going to be able to take a trademark name like Gorilla Glue and get a copyright on Gorilla Glue. No, but if there's a logo associated Gorilla Glue that includes some artwork, you could get a copyright protection on that possibly. And so let me just also say that, copyright could protect all the content of a website. So we found for a lot of our clients that are in e-commerce, you copyright your entire website. Infringers are lazy and they will rip off your photographs when they want to sell a similar product to you. So one interesting note in relation to in cannabis and copyright is, some people are also experimenting with getting copyright protection for their logos if they're nice and distinctive, or potentially for their packaging if there's really artwork on the outside of it. So that's one application to this field that I think it should be noted in relation to copyrights.
But so if I try to do that, if I try to copyright, my packaging, my creative design of my packaging, and it's clearly cannabis or it's touching the plant, the federal government's going to say no. right?
No, is you don't run into the same issues in copyright because they do a much more limited review. You're not saying what goods and services you're, using in relation to. Really, when they review a copyright application, it's almost a rubber stamping process. If they look at it and say, you know what, there's enough originality here. This isn't just two squares next to each other.
Yeah.
Right? They say, look, here's a logo. That's a really nice Rasta lion, Bob Marley's family.
Yeah.
I would really put some effort into drawing that. You could get a copyright registration. And then if someone comes up with a that's too similar, copyright infringement. And copyright infringement is actually a really nice weapon because the Copyright Act has built into it, a certain amount of damages that are pretty onerous.
Yeah.
So whereas infringing a trademark, most of the time you're looking as, a good result is to get that person to stop infringing. If someone infringes a copyright registration, you potentially could get money out of it. They could have to pay damages.
Yeah.
So next is patents.
Okay.
And patents are actually very interesting in the cannabis world because there are patents already that have been granted on different types of strains. Mm-hmm. There are patents regarding, that are extremely valuable in terms of methods of extraction to, convert cannabis flower into, oil. Mm-hmm. We've already seen our first cannabis patent litigation got launched, I think, about a month ago. And there's also something even more interesting is there's a patent troll lurking, and there are white knights trying to fight that patent troll. Yes, there is a company called Biotech Institute out in California that people are concerned is going to become a patent troll. And for those unfamiliar with the concept, we're talking about parties that have really saddled patent law in the courts with a bunch of litigations. Effectively, I go out, I register a patent, and rather than actually trying to monetize that patent by innovating or anything, I am just going to take that patent offensively as a weapon by suing people and effectively extorting settlements out of them or royalties out of them. Yeah. And so there's a really very, very cool GQ article, I think a year old at this point, that I would recommend friends of the pod check out, in which the GQ reporter, found out that this Biotech Institute was, applying for patents on all sorts of different strains, on, broad swaths of cannabis plants itself, and was trying to figure out who was behind it. But the bottom line is this party is spending a lot of money to own a lot of patents, and there's a large concern that these people are going to turn around and just start trying to sue everyone in the industry and really kind of cripple innovation. And frankly, it would be completely unfair from the beginning because one of the concepts in patent law, and I'll give the disclaimer that I'm actually not a patent barred attorney, but we have some wonderful attorneys at our firm who are very knowledgeable types, that if, the requirements to get a patent has to be non-obvious and there can't be prior art. You can't just take someone's already done and say, I'm going to get a patent on it. That's reasons for invalidation. That's effectively fraud. Okay. And so what's happened is, this party, Biotech Institute, is being super aggressive, saying that, everything we're doing is innovative. But someone saw, because apparently this happened with the human genome, that once you sequence the genome, a bunch of people got patents that they shouldn't have gotten in different parts of the genome. And so white knight, I think there are two groups that recognize the potential for abuse in relation to cannabis. And so they sequenced the cannabis genome. And what they're going to try and do is if, parties like Biotech Institute or other places try and enforce these patents, they're going to have evidence that these strains or whatever part of the genetic sequence of cannabis it is that these people are trying to protect and enforce, that they could say, oh, no, sorry, that's been out since 2007. You filed your application in 2015. Let's invalidate that. So it could end up being very, very interesting. So interesting, in fact, that I, as a non-patent person, have been reading all about it and learning about it.
So who funds the White Knights? I mean, what is their motivation? What are their underpinnings?
There are two different white knights. I'm not sure if one is a not-for-profit, but I tell you that with the high stakes, the amount of investment in this industry, the billions of dollars, that if this part, some of these potential patent trolls start going on the offensive, I don't think that there would be, and the cost of fighting and invalidating a patent is very expensive. We're talking, easily six figures. I don't think you'd have a problem with multiple parties getting together and ponying up those figures to ensure that they don't have to pay an ongoing royalty to some patent troll in perpetuity.
Yeah.
So it could be interesting.
The enemy of my enemy is my friend.
Yes. And then the last box that we call, typically falls under IP are trade secrets.
Okay.
And so the example that I always love to give of trade secrets are Colonel Sanders 11, blend of 11 herbs and spices. I used to be a lot more familiar with that until my wife wisely has cut down on my fast food habit. That doesn't prevent me, however, from whenever we're in the car and we drive by KFC, from me going, ooh, the Colonel. And then her keep on driving. So the Coca-Cola recipe is also a good example. She's totally going to listen to this. I might get in slight amount of trouble.
Exactly. Not my fault. Not my fault.
She's got a great sense of humor. We'll laugh about this. I'm a lucky man. Let me just say that.
On the record.
Coca-Cola, right? And so the idea behind a trade secret is, it could potentially run in perpetuity. If Coca-Cola had, say, patented its formula, eventually that goes into the public domain, just as we see with generic drugs. But by protecting as a trade secret, kind of like a Lord of the Rings, keep it secret, keep it safe, you could prevent people from infringing that in perpetuity.
Just clarify that for me, because I think I get it. But because a patent, you have to demonstrate and show and illustrate what it is you're trying to patent.
Yes.
A trade secret, you don't have to reveal the underpinnings, do you?
The whole purpose of it is that you do not.
Yeah.
And you consistently maintain it as a trade secret. So you need to have, as part of your business's best practices, we're talking about whenever you hire anyone who's going to be exposed to whatever the secret is. Let's say it's a specific method of extracting.
Yeah.
A specific method of extracting, super high THC content, better than anyone else in the market, right? Anyone who's going to come in contact with that needs to sign an employment agreement, the non-compete, and a confidentiality clause. And then any third party, say that you need to develop some of the technology or to manufacture the product for you, they have to also be tied to it. Anytime you're printing anything relating to it, confidential, material, if you don't maintain the secret properly, you lose your claim and you could lose your secret. So it's very, like I said, practices need to be in place to maintain the secrets.
So those are kind of 4 boxes. Now, some of these run amok with the federal legislation. Some of it doesn't. From a sort of practical business owner point of view, how do I start deciding whether or not I need, or I'm going to start intersecting with some of these things? What is it that I do, either in terms of my business operations or business process or business transactions, that are going to start touching these things, and how do I start assessing my risk, or at least figuring out where I need to be mindful when it comes to intellectual property law?
As early in the process, you hire an informed intellectual property attorney, preferably a boyishly good. Oh, wait, sorry. I'm sorry, I forgot. We're only doing the audio. I'm being completely honest, right? I mean, you need to, the problem, look, besides people in the cannabis industry that I assist, I'm helping startups in all different industries. Yeah. And one of my main jobs, I always say, is as an educator. And the earlier that you're dealing with an IP expert, the less likely you are. I always say this, right? Look, when you're starting a business, every dollar counts. But when you're talking about intellectual property, which could end up being some of your most important assets, right? A dollar spent now could save you $10,000 later. And certainly at the point where you're looking to raise funds and get investors, one of the first things that any investor is going to do is say, okay, is your IP in line? Yeah. Do you have your trademark registered? Oh, you have kind of a patent-specific business model? Did you file for your patents? Or did you start selling, something that's supposed to be covered by a patent and then shoot yourself in the foot and you can't get patent protection anymore because, you started selling more than a year ago? So I just think that, get educated as quickly as possible by talking to an IP attorney. I mean, I talk to prospective clients all the time, right? And I'm not, they're not necessarily going to become a client right then. I'm not charging them for the education. And what happens a lot of time, I believe in karma. These people go on to do great things and they circle back, and I have a client, right? Yeah. But speak to someone, and people don't think of attorneys like they do of doctors, right? I like to say, I'm in a I'm the black sheep in a family full of doctors, right? So what I like to say, whenever I'm at family reunions, I'm getting a lot of flack for it. And what inevitably happens is these doctors, my family come to me and they say, hey, I need your help with this real estate issue. And I say, that's awesome. Right? You're a cardiologist, right? Do you have people who come to you and ask you to look at something growing on their skin?
Yeah.
Well, it's the same thing,
Yeah.
right? So when you're considering intellectual property issues, make sure that you are talking to someone who is an intellectual property attorney, and all the better if they have experience in this industry because of the specific wrinkles, because of the federal illegality affecting the ability to trademark a cannabis strain. Someone who's familiar with filing state trademark registrations if you're dealing in a plant-touching business. So that's what I'd say.
Yeah.
As early as possible, talk to an IP law in cannabis and all other businesses.
A couple of scenarios or situations that I've seen, I'm kind of curious to understand the intellectual property angle to them. So these brands like Bob Marley and stuff is coming out with now cannabis brands, and they're making cannabis products, and they've got all these packaging and everything. It's like, what are the dynamics for these folks? So they've got a brand, which is a brand out there in the world that is, I'm assuming they've got protected in various ways. Now they're getting into this cannabis stuff. What are the risks or what are the complexities that they face trying to bring these brands into the cannabis space? And do they have problems, or are they protected because of the way they've set it up?
All right. So we're talking about a specific example of like a Bob Marley brand that sells
a pre-existing brand who's now coming in and
So what we're seeing already is a lot of celebrities that have any association whatsoever with cannabis have their own lines, right? So there's a Tommy Chong line, there is the Bob Marley line. So let's take Bob Marley for an example. Yeah. And his family owns the rights. I actually just went to the Wailers concert a week ago, which was fantastic. I was just singing every single word, swaying. I spent my first 15 birthdays in Jamaica. Small wonder that I like reggae and interested in certain industries. But for Bob Marley, right, they sell shirts, they, license his music, and they decide to make the move into the cannabis industry. Mm-hmm. So you're not going to be able to get a trademark registration federally for Bob Marley. I think it's called like Marley Natural is their brand name. Yeah. Marley Natural in respect to cannabis, but they're going to, I'm pretty sure I just checked, they have probably trademark registrations for Marley Natural in relation to smoking accessories. Yeah. And then I would almost guarantee you that in the specific states where Marley Natural, cannabis is sold, they have state registrations in each of those states.
So they go state by state. And is this something people can do before? Can they go in and do this in all 50 states right now, even if it's not legal in the states?
Bruce, fantastic question, right? You could do that on the federal level by what's called an intent to use trademark application. But on the state level, there are only very, very specific states, I think actually 2, that have any equivalent intent to use application. So you'll see that, yes, there are certain astute parties who know what those specific states are, right, and will file an application, say, up to 6 months ahead when they're actually going to start selling in the state, just in case someone else would come along using a similar name to cut them off and lay the groundwork for their protection.
Because otherwise I can only do it once I've got the product. Like I'm actually actively selling the product. I can't be speculative. I can't say, I want to lock this up, so I'm going to file this on the state.
No, a fantastic question that I should have addressed right from the beginning. But yes, right, you need to have use in the different states. And then it gets interesting in relation to specific states because some of them rely on the federal classification of goods. So you can't say there's no classification under the federal system for cannabis, marijuana, right? So instead, you're going to be saying things like smokable plant or something, something along those lines. Or if it's, an infused edible product, then you just get the registration for that product in general. You're not going to get it for barbecue sauce containing cannabis. You're going to get your, state trademark registration for barbecue sauce, most likely.
And so then what prevents, dispensary or company in a local state from just creating their own Bob Marley cannabis product? How do I think about it from the consumer point of view? How do I know that's really the Bob Marley brand versus someone who just came up with their own kind of logo and stuff and is calling it Bob Marley, cannabis?
Look, an infringement happens, right? So it's possible. So I'm in a consumer, and there's an infringer who comes along and some unscrupulous dispensary and starts selling something that says Marley Natural over it. Look, that's the whole reason that trademark law exists, right? You are a brand that sells quality, right? People associate your name with that quality. You are building up goodwill. So the whole purpose of protecting trademarks is to prevent parties from coming along, stealing your name and getting the benefit of the goodwill that you built up. So what happens? you have to enforce your trademark. You have your state trademark registration for Marley Natural. If someone comes along and you find out that someone's doing that, you send a cease and desist letter and you nip that in the bud as quickly as you can.
Yeah, so a lot of it is taking action quickly. And how do companies monitor this stuff? Like, how do I know that that's happening? I'm just relying upon reports from the public. Am I out there mystery shopping to figure out what the competitors are doing?
There are different levels of how you go about doing it. In certain, there are things that we call watching services. There are third-party watch services. You could be paying, hundreds of, dollars a year. It's nothing crazy. I mean, you get to common law searching, and so essentially there are people watching for you. My clients, what they do is they go, as pretty frequently on a weekly basis, they search for their names and they see if there's anything else out there.
Yeah.
And so certain people watch on their own, but it's also, you can outsource that to watching services that are very, very comprehensive. And so they'll cover federal applications, they'll cover state trademark applications, they'll cover business names, which don't necessarily equate to trademarks if that's just the name of your business and not the name that people associate with you. What we call common law. So common law is, since trademark rights flow through use in the US, common law is who's using it, which is super relevant for the cannabis industry because most people are just using it. A lot of companies don't necessarily file for the state trademark protection, and a fair amount of them cannot file for a trademark application federally. So keep your eyes open, your ears open, maybe use a watching service and do some policing on your own.
Yeah. So then sort of two other big picture questions. The first one is international. Like, how does this stuff kind of play out now that we're really looking at an international cannabis market? And you've got Canada is now legal, Israel, Germany, like you've got all these countries that are now legalizing cannabis in various ways. And you can answer this kind of with the other one too, which is, what happens when it is federally legal? What's the, assuming that at some point, and we won't prognosticate timeframes necessarily, but assuming that it goes legal on a federal level, like what do people need to do to kind of prepare for that? Or is it naturally going to kind of fix itself? And what are the kind of the dynamics that will change once that happens, both domestically and then internationally?
So to first address, the different foreign countries, we have clients that are businesses in foreign countries that are starting to look to enter into the U.S. market. Yeah. And so you have to be very, very strategic, right? So the same issues apply ultimately. Yeah. So whereas in certain fields, a lot of times we have our foreign clients and they can come in immediately and take their registration and file the application based off of it. You're not necessarily going to be able to do that. So to address the second part of the question, which is going to be really interesting, is when that last gigantic domino falls, and presumably fingers crossed it becomes federally legal, then I think it's going to be this green rush. People are going to rely upon their use in different states. But one of the interesting things is that, in order to obtain, trademark registration, there has to be use in commerce, which means interstate use in commerce, which means goods going from one state to another, or possibly, people from multiple states coming to one. But what's going to happen is there's just going to be a gigantic rush. And what's going to happen is when it seems like it's even getting close, a lot of people with the money are going to file intent to use trademark applications, months before then. There's strategy involved, ultimately. Without a doubt, as soon as it goes legal, there are going to be a ton of trademark applications relating to this industry being filed. Yeah,
it's going to be interesting to see how that builds up and where we are at that point and what's going on. John, this was great. So mission accomplished. So I learned a lot, and it was fun. That was really helpful. I really appreciate the time. If people want to find out more information about you, about sort of the IP side of cannabis, what's the best way to get that or contact you?
All right. So my name is, Jonathan, Jonathan. Last name is Purow, P as in Peter, Urow. I'm the only one of me. So if you Google me, I'm the one you'll find. And then the other thing I'd say is our firm name is Gottlieb, Rackman, and Reisman. Our website is easy. It's just the initials grr.com. And my email address, if you want to reach out directly to me, is my first initial J, last name Purow @grr.com. And like I said, I'm happy to speak with anyone, free of charge, see if there's a way we could help, and go from there.
Awesome. And I'll make sure that those links and email addresses are on the show notes here so people can click through. Again, John, this was great. I really appreciate it. I'm looking forward to keeping in touch and seeing how all this kind of plays out as the states continue to convert and continue to pass legislation, and as we'll figure out what federally happens here, when it happens. But I really appreciate the time.
Thank you for having me. I really enjoyed it, and I hope that the friends of the pod enjoy it as well.
I'm sure they have. Thanks again.
You've been listening to Thinking Outside the Bud with business coach Bruce Eckfeldt. To find a full list of podcast episodes, download the tools and worksheets, and access other great content, visit the website at thinkingoutsidethebud.com. And don't forget to sign up for the free newsletter at thinkingoutsidethebud.com/newsletter.